everyone. This is Samantha from the Law Offices of Samantha Wolfe, and welcome to this month's virtual seminar. So I'm excited because we're actually doing a three-part installment, and we're going to have three presentations where we're talking about estate administration, breaking it down into smaller bite-sized pieces. The thought being that if you had questions about how to start an estate or administer an estate, you can come here and check this out, and it breaks it down as opposed to it being in one long presentation. So I'm excited to be able to bring these next three presentations to you. Today we're going to do the first of three. So we're going to go ahead and jump right in. Let me share my screen here. All right. So we're calling today's presentation Easy Path to Estate Administration, Help My Loved One Just Died. We're going to go over how do you administer an estate, and today we're just going to do the opening, the entry. So we're excited to bring that to you. We do this as part of our mission at our office. It's really important that we bring education to our clients, to our referral sources. It's part of our mission. So that's why we do so many of these seminars and why we have a YouTube channel where we post it. We appreciate you guys being a part of it. And thank you for viewing. Check out our other videos on our YouTube channel as well. So let's say you have a loved one that just passed away. What should you do? So a lot of times when we're watching movies or we're reading books, there's like a formal reading of the will, and usually that's where all the drama happens. Usually at our office, there's not necessarily a formal reading of the will where we have the family come in and gather around the table and the attorney actually reads it. We can do that, but very rarely do we actually do a formal reading of the will. Instead, what typically happens as part of the estate administration process, which we'll get into in the next couple of slides, we are required to notify the beneficiaries that someone has passed away. And as part of the notification process, we do send a copy of the will to the beneficiaries. And so that's really how they see the will for the first time. But we don't actually formally read the will unless that's a request of our client. We do also have our client try to keep us updated on personal property that they might have specifically outlined going to different people. And this might be on a personal property memorandum where they've listed certain items, described it, and then listed who they want to receive that. So we always try to gather that information as well so that when we're interacting with our beneficiaries, we can make sure that we're giving the best information that we can. There might be a letter that's signed by our client. Anymore, there's videos where they might have left a video for their loved ones, either outlining why they did certain things in the will, or sometimes it's just a sentimental letter, video that they wanted to make sure their family received when they passed away. We always try to make sure if there's a document that might be signed at the bottom, is that a codicil to the will? So we prefer at our office that when a client wants to make changes, we might have them execute a new will or actually execute a codicil. We've had clients, though, actually write it themselves and sign and date it. We've had them put post-it notes on different assets that they wanted to go to different people. Pictures are a good example where we had clients do that. And then jewelry is another one that clients often specifically bequeath. So we try to identify that so we can make sure that we're properly distributing those assets. And our job at our office is to make sure we're representing the executor. That's typically what we do as part of the estate administration process. So we're trying to make sure, was there jewelry? Was there any personal property? Were there any car titles? Because all of those things are important. Only a surviving spouse should continue to drive the vehicle, because until we get the title transferred, we need to make sure for liability purposes that we're protecting that executor. So that's why we ask for all of that information. The biggest hurdle that we have to address right out of the gate, and that's why at our office we typically have an intake sheet completed where we detail the different assets, and that's because we're trying to determine, is there a probate estate? And a probate estate is just assets that are going to pass through the will. When they have to go through the will and be administered that way, we call that the probate process. And so when we say, is there a probate estate, we're just trying to figure out, are there assets that are actually going to be distributed under the will? Now, there are certain assets that are not probate assets. So, for example, if we have beneficiary designations or we have a joint owner, that's not a probate asset, meaning it's not going to go through the estate. So, if we have those assets, we like to identify that. Now, it doesn't mean that there's not things that need to be done with those assets, because if there's a joint ownership or a beneficiary designation, there still might be Pennsylvania inheritance tax if the decedent died while they were a resident of Pennsylvania. But what the probate estate does is it just tells us, are we going to have to get an executor appointed, file paperwork with the Register of Wills? So when we ask what is a probate estate, it's assets that have no beneficiary designation, no joint owner, no transfer on death, pay on death, and that are not owned in trust when the person passed away. Those assets are going to be making up our probate estate. That's the assets that are going to be distributed according to the will. There are certain situations in which probate is not required, and the exciting thing is that this law just passed at the end of 2025. So how it had worked is that if you had an account at a bank that was $10,000 or less, you typically did not have to probate as the executor in order to get access to those accounts. Starting at the end of 2025, which now goes into effect at the end of January 2026, they increased the number from 10,000 to 20,000. So if an account is $20,000 or less, then you typically, the executor does not have to probate in order to access that account. That's a big deal because a couple of years ago, I had a bank account, which was the only asset. It was actually husband and wife. Wife died first. For whatever reason, she did not have it jointly owned with her husband, the bank account, and it had $19,000 in it. And so it was over the $10,000 threshold. And as a result, we had to probate the wife's estate so that the husband could access that $19,000. If this happened after this new law went into effect, we wouldn't have had to probate. We could have closed out that account with $19,000 in it because it had $20,000 or less, and we could have had husband access that account without having to probate. So this law is a big deal. I'm thrilled by it. So starting, it takes effect at the end of January of 2026. So if you don't want to have to probate, you need to make sure that everything is titled in the name of the trust, has a beneficiary designation, has a joint ownership, or if it's in a bank account and it's less than 20,000, you can close that out and distribute to a family member. So a spouse, a child. Typically, the bank requires a death certificate and a receipt of the paid funeral bill, and that would allow that account to be closed out and then paid to the family member without having to open an estate and have it paid to the estate. So that's wonderful news. Other administration that you might have is that if you do have a trust, if you do have a beneficiary designation, if it is jointly titled, it does not go through probate, but there still might be some things that need to be done. So for example, if it's in a trust, the trust might need to be administered. You might need to, with beneficiary designations, fill out claim forms. If it's jointly titled, you may need to retitle it. You may also need to pay inheritance tax. So when we're talking about administration, it's just knowing, do I actually have to file the Pennsylvania inheritance tax return, disclose the asset on there, and pay inheritance tax? Now, if it is between husband and wife and it's jointly owned, then there's no inheritance tax, so we don't have to file an inheritance tax return. But for other beneficiaries, we'd still have to worry about that. So that's why we say, even though there's no probate, there might be other administration that has to happen. Dates to remember. As the executor, our office likes to make sure the executor knows that the Rev 1500, that's the Pennsylvania inheritance tax return, that's due within 9 months of the decedent's date of death. So if we have somebody that died January 1st, then we count out 9 months, February, March, April, May, June, July, August, September, October. The inheritance tax return is due within 9 months of the date of death. And that does mean that the tax is due within 9 months of the date of death. Now, you can file an extension if for whatever reason you're not going to be filing the return, but you still want to pay the tax because otherwise interest and penalties do accrue if there was tax that was due. So even if we're going to file an extension, we try to pay the tax or everything that we know tax-wise that we need to pay, so that way that we're not accruing that interest and penalty. If you pay the tax within 3 months of the date of death, then there is a 5% discount on the tax that's owed. Not a 5% discount, just 5% discount on the tax that's owed. The other date to remember is that 1 year from the date of the first advertisement. So as part of the probate process, when you're administering a will, you do have to advertise it in a paper of general circulation. And when I say advertise, you're advertising the decedent's death in a paper of general circulation and in a legal journal 1 year after it's been published in both of those publications once. 1 year from that date, creditors are barred from coming forward. That's why you want to make sure you advertise. It's required by Pennsylvania law, and you want to make sure you do that because it stops creditors after that year. Probate versus inheritance tax. This is what I was talking about earlier. Just because you don't have to probate doesn't mean that there's no Pennsylvania inheritance tax. Assets may still be subject to Pennsylvania inheritance tax, even though you don't have to probate. So for example, retirement. If you have a retirement account, typically you have a beneficiary on there, and depending on the beneficiary, there might be inheritance tax. Now, there's no tax on spouses, but if it would be to a child, there would still be inheritance tax there. And you always want to file a Rev 1500 or Pennsylvania inheritance tax return for retirement, even if the spouse is the sole beneficiary. And that's because Pennsylvania law requires it. They require you to file a return, even if there's no tax that's due, if there's a retirement account. Let's talk about intestate rules. Now, when we're talking about intestate, that means that there's no will. And so Pennsylvania kind of instills their own estate plan in situations where there's no will. If we have a surviving spouse, 100%, if there's no surviving issue, meaning children or parents living, then it all goes to the surviving spouse if the decedent had no will. If there are children or a parent that are living, then $30,000 goes to the surviving spouse and 1/2 of the estate. So Pennsylvania does not assume that spouses like each other enough that they would leave their entire estate to each other. So when clients come in and they ask, well, do I need a will? Yes, if you're married and you want to make sure your estate goes entirely to your spouse and it's not jointly owned and there's not beneficiary designations, if it's going to actually go through the will, you want to make sure you have a will, because otherwise Pennsylvania's estate plan is that your spouse only gets half. Now, if we don't have a spouse and there are children, then it goes 100% to the children. If there are no children, then it goes to parents. If there's no parents, then the estate goes to the siblings. Now, remember, this is if someone does not have a will. That's why it's so important that you have a will, because then you aren't stuck with what Pennsylvania says your estate plan should be. If you don't have a will, because remember, a will say, where do your assets go? It also says, who is my executor? If you do not have a will, Pennsylvania does have an order of priority of who can serve as the executor. So for example, first thing is who's listed in the will. If we don't have a person listed in the will, or we have somebody but no backup and that person has died, then the residuary beneficiaries listed in the will can serve as the executor. If there's no will, then it's the surviving spouse. If there's no spouse, it's adult beneficiaries. And the priority is to larger inheritance shares, meaning that if one person's getting 60%, they're going to have the priority of serving as the executor. Now, the Register of Wills does have the discretion to determine who's best suited to serve as the executor. So just know that too. If there's no surviving spouse, no adult intestate beneficiaries, it might be a creditor that's appointed as the executor or other fit persons. That would be who the Register of Wills would say, okay, if you're going to petition, we will allow you to serve as the executor. So that's another reason why you want to make sure you have a will, because again, otherwise Pennsylvania has to say, okay, you don't have a will naming somebody, we're just going to pick somebody to serve. And this is the order in which we'll pick them. So just make sure you have a will. Now, before you can do certain things, you have to be appointed as the executor. So there are going to be bills that are coming in. Usually we get calls about changing the locks or passwords on accounts, transferring assets, closing any accounts, opening any bank accounts, those type of things. You have to be appointed as the executor. You're not going to be able to act until you've been appointed. Even if you're named as the executor in the will, until you have the appointment through the Register of Wills, their institutions are not going to allow you to act. They need the Register of Wills to grant letters of administration or letters of testamentary. Letters of administration, this is the legal document that allows you to administer the estate. The will you need to petition the Register of Wills in order to get them. They'll want a death certificate and the original will, if there is one. If the original will is missing, you may have to petition to probate a copy. And then you'll get sworn in as the executor or as the administrator. And many counties in Pennsylvania now allow you to do this virtually. It may mean that you have to provide them with a copy of your driver's license before and other documentation before, but a lot of counties do allow you to do this virtually now. You can, in Franklin County, for example, still go to the Register of Wills and do it in person too. So things to make sure to do. You want to make sure you're reaching out to the deceased's financial advisor. They're always very important partners in this area because they help things run smoothly. It's usually much easier if there's a financial advisor because that person can help fill out claim forms, help do what's needed to administer the estate. You want to make sure you're keeping track of incoming bills, gathering paperwork, work on getting those letters of administration or letters of testamentary. And then at that point, once you've gotten those letters, that's really what starts the administration. That's what gives you the green light to do all the other things that you need to do. So that's why we wanted to do this presentation first as part one, because this is saying very first thing you need to do, locate the will, figure out who's going to be our executor, get appointed. And then in part two, we're going to talk about the next steps once you've gotten appointed. So hopefully this was helpful. You're always welcome to call our office, 717-655-2676, to schedule an initial consultation. We'd be happy to help you. And let me see if there's anything else I have in this slide. Okay. So thank you so much for joining us. I'm Samantha with the Law Offices of Samantha Wolfe. If you have any questions or concerns about administering an estate, you can check out part two, or you're always welcome to call our office and we'd be happy to help provide any information that we can. Thank you so much.